Hello, everybody. Welcome back to our podcast on reductions in force, or RIFs. This is part two. My name is Doug Massey, president of AFG Local 17 here at VA Central Office. A few weeks ago, we had BB Roberts on to break down the key legal aspects of RIFs, and she did an incredible job. So much so that my inbox was flooded with messages from our members afterwards thanking her. And today, we're going to continue that conversation with another top expert in federal sector labor law, Peter Broida. Before we bring Peter on the stage, I just want to make a few comments about these RIFs, reductions in force at the Department of Veterans Affairs. There's the number we've been told is 83,000 jobs are on the chopping block. Recently, the chief human capital officer at the Internal Revenue Service in a deposition said to do a lawful RIF, just the planning takes between 12 and 18 months. And that's very different than what's being proposed here. Many of you may remember, or some of you, under President Bill Clinton, there were 400,000 jobs of the federal workforce that were reduced. That was done very differently. It was done over a 7-year period. A lot of it was incentives, VERAs, the Voluntary Early Retirement Authority, buyouts, things like that. What being proposed by Elon Musk is completely different. I also want to say, and a lot of us know this, that VA healthcare consistently outperforms non-VA healthcare in patient satisfaction. I know Secretary Collins says that they're going to cut 83,000 jobs and it's not going to negatively impact the care for veterans. I don't think he's being very candid. He's claimed that over the last decade, the VA has kind of been mismanaged and falling apart. That's not shown by the data. So let's call this what this is. This is kind of an attempt to dismantle the Department of Veterans Affairs because there's billions and billions of dollars to be made in private healthcare. So let's get to our guest. Peter Broida has decades of experience representing federal employees and unions before the Merit System Protection Board, the Federal Labor Relations Authority, and federal courts. He's literally written the book on Merit System Protection Board law, actually several books. His litigation, his analysis, and advocacy have shaped the legal landscape of federal employment law. So let's bring Peter on the stage right now. Peter Broida, we're honored to have you with us, talk about reductions in force. Thank you very much for joining us here today, Local 17.
Well, thank you, Doug, and thank you for the invitation. I thank AFGE for introducing me into this career field back in the late 70s, before many of you were born. I had joined the AFGE National Office legal staff, which was then about 6-7 attorneys and a few paralegals to do civil rights litigation, and stayed with them a while, traveled all over the place, handling MSPB cases, EEO cases, FLRA cases, grievance arbitration, so forth. And then I just continued with it. I had to stop the traveling or get divorced. I chose to keep the wife and not the job, so moved back into private practice. Here I am, I'm still doing this stuff, and kind of getting up into the elder years, but still have some faculties. So let's see if I can provide some training to you. I'm going to take questions at the end, and they will be filtered through Doug. And I do have some PowerPoints, and there are some reference materials that I'll be talking about. If my voice fades or dissolves during this, understand that I'm doing this from my office in Arlington, Virginia, not too far from my home, also in Arlington, which has a yard where every single tree is blossoming. And I feel the effects of it, as some of you probably do too, not from the same trees, perhaps. So, Doug, let's get started. We can put my PowerPoints up.
Great.
Hey, there they are. Okay, so, ladies and gentlemen, isn't this wonderful? One more PowerPoint presentation. I don't much care for PowerPoints. They have the singular advantage of keeping me on track. Otherwise, I would tend to wander and talk to you about anything other than RIFs. But here we are. And what I won't be talking about today are the constructive RIFs, all these probationary and trial period terminations that have been occurring by the thousands have been challenged in courts, will continue to be challenged in courts, challenged through union lawsuits and arbitrations and mass MSPB appeals and also special counsel complaints. That's what I'm not going to talk about. We'll just talk about regular, ordinary RIFs, which haven't been around much in the past few years. And so what I'm going to be talking about here will be the RIFs, and then in particular, the collective bargaining contract that has 100+ pages, collective bargaining contract. In one particular article, it's, was it 28 reductions in force in that contract, and then grievance challenges under your grievance procedure, which is Article 40. There we go, 43 of your contract. Now, in order to do this stuff, RIFs are complicated, but they're not that complicated. It does help to take a look at some reference materials, and I have listed some of them here. A material from the Congressional Research Service, which gives a short overview, an OPM workbook, which isn't bad, which comes equipped with hundreds of pages of appendices. Some other materials from the Office of Personnel Management, which of course is now getting very interested in the RIF process and pushing agencies. And then there's some materials that I sent over to Doug, which I don't list in my PowerPoints here. And these are materials that are in part readily available to you. For example, the OPM regulations at 5 CFR Part 351. You really need to read these things. You'll probably need to read them twice because some of them don't make a lot of sense. And I look back in preparing for this seminar at a couple law review articles written a long time ago on RIFs, and they didn't make any more sense in critical points, particularly assignment rights, which are part of RIFs, than did the OPM regulations, which struck me as funny because what can you do if the regulations aren't clear? How can you clarify them? But I thought somebody must have done something to make this system more clear. And I thought back, way back when in the day, before the Office of Personnel Management issued their regulations, there was a thing called the Civil Service Commission. And the Civil Service Commission, which went out of business in about 1978 when the Civil Service Reform Act came into effect, had also published regulatory guidance on reductions in force in a different form. They had the Federal Personnel Manual. The FPM had many chapters. One of those chapters, yes, was Chapter 351. So I went back. I actually have a copy of this thing. That's how old I am. I have a copy, probably one of the few extant copies in the United States, probably not too many else in the world, and took a look at Part 351. And it actually made sense. It was written for people who needed to understand the process, which is not the way OPM structured its regulations. And if you will take a look at the old FPM chapter, plus FPM was supplemented by what they called letters. There was an FPM letter, and I've also provided that to Doug. If Doug will post that on the AFGE website, then you can take a look at that, and I think you'll find your time is well spent in taking a look at those two materials, those two items from the Federal Personnel Manual. But anyway, getting beyond the research material, and as I look to my left here, I'm looking at a set of PowerPoints that helps me to understand what comes next. What is a reduction in force? It's basically just a process of downsizing the federal government and then setting up a retention order, kind of a seniority list for people who are going to be displaced as a result of the RIF. Now, not everybody is going to be retained. Some of the people are going to be released. They will no longer be federal employees, not at least in that agency. The reasons for a reduction in force: lack of work, shortage of funds, agency reorganization. How? It's done agency by agency under the OPM regulatory system, and significantly, I say possibly, but significantly in this case, through provisions in the collective bargaining contract. And a lot of people have over the years denigrated the collective bargaining process in the federal sector as meaningless. You can't negotiate, at least most agencies, you can't negotiate pay, insurance benefits, things that are, things are very significant. And so people describe it as parking space negotiations. Well, yeah, you can negotiate about parking spaces, but you can negotiate a lot more. And what I think the Trump administration is finding out now is that these contracts that have been negotiated, and the AFG Local 17 contract is a good example, if they're carefully constructed, they act as a significant restraint on governmental power. And I don't believe that the people who are running the administration had really considered this limitation, the contractual limitation established by these contracts. So AFG Local 17, you did a good job in negotiating your contract, and it does have a RIF article, and it does provide some substantive protections. But getting back to the OPM regulations, they were last amended in about 2008. They've been in effect in their present form since 1986. There's been very little RIF activity. Once in a while, the Postal Service undergoes a massive reorganization. Hundreds of thousands of people get moved around, and that may or may not result in reductions in force. Other than that, there's been very little development in the law in the past 15, 20 years or so. Now, the OPM regulations on RIFs establish a right of appeal to the Merit Systems Protection Board from a RIF, or the ability of an individual, if they're able to grieve the action under a collective bargaining agreement. The ability to appeal a RIF to MSPB is not a result of statute. It's certainly not an MSPB regulation. It's an appeal right that was created by OPM, and it could be taken away by OPM, although I don't think that's going to happen. Who's covered for our discussion today? Executive branch employees, competitive, accepted, probationers, trial periods. Probationers? Yeah. The OPM regulations extend the right of an appeal to probationers. Normally, if a probationer is terminated, there's not much you can do about it, assuming that the union would show some interest in it, unless perhaps the probationer was somehow active in the union and the discharge was an unfair labor practice reprisal for union activities. Other than that, normally they can't appeal except for marital status, political affiliation issues, which are very rare. But not so with respect to RIFs. Even the probationers or the people in accepted service on trial periods can appeal to the MSPB, or by extension through the collective bargaining process and the grievance procedure to the MSPB, or if it's taken that far, to a labor arbitration. So what are the first steps in a RIF? Well, VA sits there and says, their control group says, what are we going to do about this? OPM and the president are telling us to reduce expense. We're going to do that through reductions in personnel. So what we're going to do here, we're going to take the Office of General Counsel, and this is just by way of example. We're going to take one group there, the number of paralegals. There's just too many paralegals. We're going to reduce them by 20%. From 80 to 60. And then that's going to be the basis of a reduction in force. And the first thing that happens after you decide what you're going to do and who you're going to do it to in a RIF is you have to set up, as an agency, a competitive area. That's the geographical or organizational bounds of the reduction in force. Is it going to be VA central office? Is it going to be the VA Medical Center in Wilkes-Barre? Is it going to be one of the VA regions, or whatever the other subdivisions are called? You decide where the RIF is going to be run. It could be national. Oftentimes, however, it's not. It's usually limited, maybe a headquarters office, maybe a regional office. And then, once you've decided the geographic bounds, you decide what type of positions are going to be affected. Now, I've chosen the example here of paralegals. It could be anybody. It could be attorneys. It could be legal technicians. It could be IT people. You name it. I'm just using one example here. And so you decide you're going to reduce the population of paralegals. What's the organization? Well, the organization is probably going to be the Office of General Counsel, right? Unless these paralegals hang out in other organizations. And then you set the geographical limitations. Is it going to be in the regions, headquarters offices? And normally, once you establish the geographic limits, it would be, assuming it's a region, for example, or maybe VACO, you look to the local commuting area, and that defines your geography. And I say here, I'm not going to just read these slides, so you can take a look at them too. But you would normally, for the meets and bounds of the competitive area and the local commuting area, look to maybe 30 or 50 miles, depending on where you are. For example, in the Washington, D.C. area, you would be taking a look at Northern Virginia, the Maryland suburbs, and D.C. Then what you need to do, once you've established the competitive area and the types of jobs that you're interested in reducing force, then you create a competitive level. And the competitive level focuses on the positions. And you take all the positions within the competitive area at a particular grade. Take a look at the types of pay schedules you have. In the VA would normally be general schedule. I will be talking here about Title V rather than Title 38. And you take these interchangeable jobs, the paralegals at a particular grade, for example, and you put them into a competitive level. That defines the group of people who are going to compete within the competitive area. And generally, the jobs of the people in the competitive level should be basically interchangeable. So the paralegals, their positions, you're going to declare them to be interchangeable, assuming there's not extraordinary specialization within the group of paralegals. And you can see here that the idea is that an agency could reassign the incumbent of one position to any of the other positions in the level without undue interruption. Now, what's undue interruption? It would be a short period of familiarization with the job. So let's say you had a paralegal who was working on veterans benefits and another paralegal who was working on land acquisition. The question is whether one could displace the other with a relatively short period of training and familiarization. And then once you follow this, so we have the competitive area, we have the jobs that are within the competitive level in that competitive area. And there can be lots of competitive levels within a competitive area. I'm just talking about paralegals. It could be lawyers, it could be legal technicians, it could be IT people, it could be court typists if there are court typists. Probably not nurses. No, we're just talking about the legal organization here, right? And then within the competitive level, you give people a relative ranking. This is like a seniority list according to the tenure of their employment. For example, career or career conditional employees will be separated. Career employees will be at one level with respect to tenure, probationers at another. You also have to subdivide them by veterans' preference, those who have preference based on their service, those who have preference based upon a disabling condition incurred during service, and also you're going to be ranking them by length of their service. That's where your seniority comes in, and the seniority through length of service will be augmented by extra years of service based upon the quality of the performance as recognized through performance ratings over a period of about 4 years. So here's what it looks like. This is what you end up with a roster. I'll call it a seniority roster. This is your retention list. Group 1, your career employees who are not on probation. Group 2, career conditional employees. Those are employees relatively recently hired and probationers. Group 3, your term and other non-status appointments. I'm not sure what a non-status appointment would be, but there must be some around. And then you subdivide the group with respect to veterans' preference. This is where veterans' preference becomes quite important because of the ranking they achieve relative to others who do not have veterans' preference on this retention list. You have your people with service-connected disability. You have people who have preference based upon their service but not a disability, and then everybody else. And then you have ranking within this based on length of service, which can include both civilian service, civil service, I'll call it, as well as military service. Again, the military component of this becomes significant in the course of a RIF because it adds into the length of their service. You might have 3 years as a federal employee, 15 years military, add them up, 18 years. And then this business of augmentation through performance ratings. Here's how it works. Over the past 4 years, you take the highest 3 ratings, average them out. And if the average is outstanding for those several years, they get a whole bunch of additional years of service credit, 20 years, 16 years for exceeds, 12 years for fully satisfactory. If it's minimally satisfactory or unsatisfactory, no credit. They probably won't be competing anyway because they'll be on a PIP and released for other reasons, right? There are 2 rounds of the RIF competition. Now remember, you got all these people on this list, the paralegals. Within the competitive area, their competitive level is paralegal, all the interchangeable jobs, and then they've been ranked as a result of whether they're career conditional, whether they have veterans preference or not, and then within each of these subgroups, they'll be ranked based on their years of service. And the agency says, well, we got 20, well, what did we do? We had 80 paralegals, right? Let's assume they're all on the retention register, all 80 of them. And the agency wants to reduce the 80 by 20. So what happens? The lowest people on the retention register get released from the competitive level. They are set adrift. The other people remain. So the lowest 20 drop out. Now, are they in free fall? Not exactly. Anyone here? Okay. Right. Okay. Round 2 of the RIF is that the agency will then determine whether a person who's released as a result of the operation of round 1, the lowest 20 have been released from their competitive level. If nothing else happens, they're going to be separated from the federal service. But no, you have round 2. The agency then determines whether the people who are being released have the right to bump or retreat to a position in a different competitive level that is held by an employee with lower retention standing. And this is where things become fascinating in their complexity. And what I'd like you to do is just read the slide. Take 30 seconds here. I'll give my voice a rest. And you read that slide. I don't like reading slides to people. You can read them for yourself. All right, if you've read the slide, you understand the release system that we've been talking about. Now we get to the bump and retreat. You have your employees who've been released from the competitive level, and we're going to first talk about bumping. What's bumping? The employee can bump to a position for which he is qualified that's held by another employee in a lower tenure group or lower subgroup in the same tenure group, if the position is no more than 3 grades below. Now, the person has to be qualified. Now, what does that mean in practice? This is going to be displacing a person in another competitive level. Now, what would that be? It's not going to be paralegals, right? Because all the paralegals were in the competitive level that we began with. So the person who is seeking to bump a person in a lower tenure group or lower subgroup would look around to find, or the agency would look around to find a different competitive level into which that person could be placed and displace an employee with the displacing employee being qualified for the job. So let's take an example. Let's say legal technician. All right, maybe there's a bridge between legal technician and paralegal. So if that's the case, if the paralegal could serve as a legal technician with basic familiarization in the job, and the legal technician is in a lower tenure subgroup, if you read it there, lower tenure group or lower subgroup within the same tenure subgroup, then that employee, who's the legal technician, would end up being displaced. Following that? Okay. The person who's doing the displacement has to be qualified for the job of the person that they're going to displace. Now, there's another type of assignment right. It's called retreat. And you can read it there. An individual can retreat into a position held by another employee with lower retention standing in the same tenure group and subgroup if the position is the same as or essentially identical to one that's previously been held by the employee. Now, what does that mean in practice? Normally, that's a position through which the employee who's been displaced initially from their competitive level has been promoted through. So, for example, if the paralegal was promoted through a legal clerk position, and they went from legal clerk 5 to paralegal GS 7, that's a position, assuming that they have a standing to do so, that they could retreat to. They used to serve in that position, so they essentially reclaim the position and displace the person, the legal technician, who's in a lower retention standing in the same tenure group and subgroup. Following that? Well, I hope so. That's where things become interesting. You have to, in order to exercise this, you have to meet the OPM requirements for the job, education, selective placement factors, and the ability to perform with undue disruption beyond what is normally expected in the orientation of a new but fully qualified employee. So you have to be able to make the transition reasonably smoothly, thereby not disrupting agency operations. Now, I note that up there, all you attorneys out there are saying, and he says there in brackets, not accepted service. So the OPM regulations distinguish between competitive service and accepted service in a number of ways, but one of the significant ways is that the OPM regulations themselves do not create these types of assignment rights, the bump and retreat, for people who are in the accepted service. Why? I don't know. I didn't write the regulations, but that's what they say. But OPM gives you now. The agency has discretion to provide accepted service employees with assignment rights. You say, really? Oh, they're going to do that? Well, probably not, but wait a second here. This is a reduction in force. It's a management action that adversely impacts employees. So what do? Hint, arrangements bargaining, right? Impact and implementation bargaining. The agency wants to exercise a management right. You say, yeah, okay, but wait a second here. We want to negotiate this beyond our contract, and we would like the agency to stay any action pending negotiation, and the subject of negotiation, for our example here, is assignment rights for accepted service employees. Now, excuse me, what's VA likely to come back and say? Well, they'll say, wait a second here. We already negotiated Article 28. All this is covered by the article. We're not going to negotiate anyway. But you can invite me back for another seminar so I can talk about the covered by doctrine. That's an interesting subject, right? But what I am suggesting here is the possibility of arrangements bargaining. And it may be that VA would not raise a covered by defense to block bargaining, but might be, I just don't know the tenor of the organization, willing to negotiate with AFG for further accepted service protection, because I did not see that protection in the contract article. Now, once the agency starts deciding exactly who is going to be released from federal employment, who is going to be given job offers through these various assignment rights, the agency is supposed to provide the employee a 60-day advance notice. And it will explain to the employee what's happening. Hi there, there's going to be a reduction in force, and here's some information about the competitive area, the competitive level, and you are it, and you do not seem to have any types of assignment rights, so we're going to release you from employment 60 days hence. The letter will also state that the agency has a reemployment priority list to try to help you, that you may be able to take advantage of severance pay, that you have an appeal to the Merit Systems Protection Board in the case of folks within this bargaining unit. They would also mention the collective bargaining contract. The agency would note the possibility of early retirement, particularly if the agency has voluntary early retirement authority. Note the ability to obtain unemployment compensation, and for employees who are able to exercise bump and retreat rights and are reduced in grade as a result, perhaps up to 3 grades, the agency will note that statutorily the employees have grade retention rights for 2 years and indefinite pay retention, which means their pay is not dropped, but they don't get cost of living increases. So the pay never drops, but it doesn't go up much either, unless they're able to get a promotion sometime. Common challenges to reductions in force. Employees feel they've been singled out. It's a disguised adverse action or a performance action. A reduction in force is not to be based on personal characteristics. The boss says, well, I just don't like Peter. He's a fruitcake. We want to have a competitive area of in Northern Virginia and a competitive level of one lawyer whose name is Peter, and we're going to get rid of this guy through reduction in force. That's not the way this is supposed to happen. It's not supposed to be personally based. Not supposed to be based on EEO considerations or whistleblowing or other types of reprisal. And the other common challenge is the failure of the agency properly to assess the ability of the employee to perform a job through assignment rights. Why? Why does this come up? Because the agency doesn't want to have the other person displaced. That person's doing a great job. Everybody likes him. The boss likes him. The coworkers like him. They don't want that person displaced. So what they're going to argue is that the person who seeks to displace that individual is not well qualified, could not perform the job without undue disruption, couldn't be trained to do that job or the additional training required in the period of 60, 90 days. In other words, they just can't function in the new job, so we're not going to give them the assignment rights. And the employee who's being displaced feels, yes, I could do that job, never did it before, but I could do it, and it wouldn't take much time, and I got a law degree or I got a paralegal degree. Why shouldn't I be able to do that job? So the MSPB then has to assess this on appeal, or an arbitrator would take a look at it as well if the defenses are raised. Now, I'm going to turn to your contract here. And the contract does provide significant protections. First, that the agency will freeze all relevant vacant positions within the facility 60 days prior to the effective date of the RIF. What's the importance of the 60 days? That's the notice period, 60 days. Once that notice goes out, vacancies cannot be filled. And when the department decides to fill up a vacant position after the effective date of the RIF, whether it was previously frozen because of the RIF or not, then the contract sets up what I will call a reemployment list, a reemployment priority list under Article 24 of the contract. Pardon me. And that's where you get to your reemployment rights under the contract, which provides some reasonable protection for employees who are released through the RIF at Section 24. You can read it. Give my voice a break here for a second. Now, the contract also supplies some additional protection for the employees. There's a placement and counseling program, a department-wide vacancy list, official time and facilities for job search. Write up those resumes, start contacting those headhunters, apply to other agencies. It gives you 14 days to consider a placement offer. We're going to offer you a position through assignment rights. You got 14 days to think of it over, take it or leave it. And then 2 years of re-promotion eligibility for vacancies that will later be filled within the competitive area for which the employee is qualified. It's good protection, and people do, in my past experience with RIFs, goes back quite a ways, they actually do get, some people do get job offers as a result of these reemployment programs, whether they're run by the agency or they're done by contract. They are useful. Your contract, your collective bargaining contract, controls a challenge to the RIF. Article 43 is your grievance procedure. It's broad scope, no exclusion for RIFs, and the union can determine whether to use a individual grievance, group grievance, national grievance. And then you have the, now I want to go over this because it's so darn important. People want to say, well, why can't I appeal to the Merit Systems Protection Board, huh? Well, it's because of this statute here, 5 U.S.C. 7121. And why don't you just read along with me? Any collective bargaining agreement shall provide procedures for settlement of grievances, and the procedures will be exclusive, the exclusive administrative procedures for resolving grievances which fall within its coverage. Now, there's more to the statute which takes out of this exclusive coverage by the grievance procedure of the contract certain matters such as adverse actions or performance-based actions, but we're not here to talk about that. We're just here to talk about RIFs. So under the statute, the contract covers the RIF. The statute makes the contract the grievance procedure the exclusive procedure for challenging that RIF. Now, can that be avoided? Yes. Under the statute, under subsection D there, if the employee alleges discrimination in connection with the matter that's otherwise usually under the exclusive coverage of the collective bargaining contract, and it's otherwise within the jurisdiction of the Merit Systems Protection Board, that individual can file with the MSPB. And since a RIF is within the jurisdiction of the MSPB under OPM regulations, then if an employee who is RIFed decides for whatever reason that they've been discriminated against and they do not want to take it up under the collective bargaining contract grievance procedure, then they can file an appeal with the Merit Systems Protection Board if they do so on a timely basis. Normally, that's not going to happen. Normally, the challenge would be through the collective bargaining contract. And there are a couple of cases here that kind of explain this. One from the Merit Systems Protection Board, this case involving the Corporation for National and Community Service, whatever that was, back in 2008, where the board talks about the exclusivity of the collective bargaining contract to challenge a RIF, except if the person alleges the type of discrimination that's prohibited under 5 U.S.C. 2302b1. And what's 2302b1? Discrimination that's prohibited by Title VII, race, national origin, color, sex, ADEA, FLSA, that's your Equal Pay Act type thing, sex discrimination under the FLSA, disability, or they throw in here marital status or political affiliation, which you're just not going to have that type of issue. But that's the type of the discrimination that will allow you to file an MSPB appeal if you allege that the RIF was illegal as a result of that type of discrimination. And then there's a case here by the Federal Labor Relations Authority, which essentially goes through the same analysis, this Department of Navy case back in 1987. Take a look at dates of these cases: 1987, 2008. It's been quite a while, hasn't it? No recent guidance on reductions in force from either FLRA or from MSPB. Now, these cases are not like the furloughs. Some of you may recall some years ago these massive furloughs when the government was unfunded, and what the unions did was, instead of taking these cases up through grievance procedures and arbitration is expensive, why they filed massive numbers of appeals with the MSPB. So it didn't cost the unions or their unit members anything. And the MSPB started getting tens of thousands of cases. Very few of them were won, but they were all thrown by the unions at the MSPB, which I thought was very clever. The MSPB may not have thought it so clever. But that's not going to happen here, because the furloughs, by statutory definition, were adverse actions within the original jurisdiction of the MSPB. RIFs are not. They come up through the OPM regulation, and then that 7121 statute makes the collective bargaining contract the exclusive means for challenging the RIFs. So that's the sum and substance of all this for all three of you who are attending, and the one of you who are still awake. I hope this has been of some help to you. It helps me to review this, because I just know that sooner or later I'm going to start getting some RIF cases. I encourage you to do some reading here, particularly those FPM issuances from the 80s. I think will be very helpful. And I told Doug, and I tell you, I will be happy now in the remaining 10 or 15 minutes to take some questions from you to the extent that I can respond to them. Doug?
Yeah, thank you very much, Peter. That was extremely helpful. We have some questions here. By the way, there's more than 3 people. The people are watching this on YouTube as well. Some of these have been answered. They were asked earlier on. Okay. What can employees and unions do to prepare for the upcoming RIFs?
I don't know that employees can do anything. One thing, well, no, there is one thing they can do. They could make sure that their position description is current and accurate. Make sure that their performance ratings are in the file, that the supervisor has put them into the file. If their position description is not accurate, I would say you would want to have a little chat with the boss to try to get the thing cleaned up a bit. Now, you're going to have some position descriptions that are very general. A GS 905 lawyer position may be very generally described, but the performance standards, the critical elements that are in the performance plan, should do a better job of describing the job. That's the employees. And the unions, once the agency announces that they're going to run a RIF, then you have the opportunity for implementation bargaining, to the extent that what you're talking about is not covered by your contract, a whole separate issue. And the union can request that the agency maintain the status quo. That is, they don't do anything pending the outcome of negotiations. And anybody who's familiar with negotiations in the federal sector recognizes that even on the simplest thing, negotiations can take forever, including impasse resolution techniques. And I don't know that the agencies are going to stand by for that. But those are some of the suggestions for employees and unions.
I guess one piece of advice we've been telling employees is go to your file, your EOPF file, and you should definitely download, print, save your performance appraisals for the last 4 years. Because if that's erased, that will cause a problem. There's a question in the chat here. It says, my HR is not updating my career status. I have 22 years total. In new position since 2018. He's in a new position since 2018. In the accepted service, hired in this current position under VRA eligibility, disabled veteran. They claim there is a team that is supposed to review, update, and correct everything, but when asked what remedy there is, they do not fix it.
Well, the same thing with making sure your veteran status, if you're a veteran, is correctly reflected. That's very important. If this stuff is not reflected properly in your OPF, goes back to Doug's comment, then I would go to the union and ask the union to try to straighten this out with a higher level of official than some HR specialist who seems unresponsive. I mean, there's no magical fix here, right? You could use the Privacy Act to request a record correction. That's going to take forever. That's not. I mean, you can use it, but it's not going to be very helpful. What you really need to do is get involved at the level of the union that can deal directly and quickly with the labor relations representatives, who in turn can work with the HR people. I think that the people at the operating level, I'm not talking about the political levels of the VA, I'm talking about the people in the operating levels, the LR specialists, the HR specialists, would like to see this stuff get done right. The risks are very complicated. They're going to make plenty of mistakes, but the union, if the union has a passably reasonable working relationship with the LR staff, problems like that should be addressed and addressed quickly.
Yeah, we do have a good relationship with the LR staff. I don't know how much of a factor that's going to be in this current administration. One thing I want to correct is that Local 17 did not negotiate this contract. You gave me kudos, thank you. But the National VA Council, President Alma Lee, she's been our president for over 30 years, probably one of the most impactful labor leaders I've met. She negotiated the contract and her team. So another question out there is, you talked a little bit about this, but what do you think are going to be the most common mistakes the department's going to make where people are going to be able to appeal it and have some kind of remedy?
Oh, well, probably the bump and retreat rights, whether people are qualified without undue disruption to take over somebody else's job who's in a different competitive level with a lower retention standing for the bump, and or in the same retention standing for the retreat. That's, people say, well, I'm qualified to do that. And the agency said, no, you're not. And then the MSPB has to figure that out. Or, well, in your case, a labor arbitrator. That's probably the most common problem. Disputes over qualifications.
And do you think, we talked about this at our local, we've done a lot of class action grievances, and those are appropriate if people are similarly situated. Now, do you see this as potential for class action? Like, say the notice is wrong for everybody, they don't do the 60 days. Do you see possibility of a class action grievance, or are these going to be more individual?
My guess is it'll be more individual. It's possible the agency could screw up a notice. It would take a lot of disorganization to do that. But let's say they come up with a notice that's 5 days short or 2 days short. That's not going to be, in my estimation, enough to set aside a reduction in force. There has to be some real substantive harm. It's not so technically oriented that the whole operation will fail on a very technical deficiency. So I think it's going to be individual. These qualifications disputes, I think that's where you'll have issues.
Okay, and this is a good question. With respect to length of service, is it length of, VA has different groups, there's Veterans Benefits, Veterans Health Administration. Is it the length of your federal career service, or your length at the Department of Veterans Affairs, or in a certain position? How do they do seniority?
Yeah, it's your whole career. If you had 32 years with the Department of the Army and then you came over to the VA and you've been there for 2 years, your civilian time is 34 years. Add on to that 5 years in military, you got a lot of time.
Okay. And let me check here. You've already answered this. Does a RIF of bargaining unit employees trigger a bargaining obligation with the union? And I think that's been answered. Let's see. Okay. They claim that there's a team.
Oh, Doug, while you're checking your questions there, when you say what are the other common problems, that issue of negotiations, that's certainly going to be a common problem. You're going to ask for negotiations. You're going to ask, oh, we want to talk about ground rules, for the next 2 years, and then we'll get to discussion over the specifics. That'll take 5 years. So, and we want you to maintain the status quo for all that time, including impasse resolution. That's going to be a major subject of contention.
Mm-hmm.
But but that's for the union. That's for the union, not for individuals.
Well, we do have a lot of experience at Local 17 with bargaining and these difficult bargaining situations. And RIFs are one of those things. I mean, a lot of people don't know about RIFs. They don't know how to do them because, as was explained, the last major RIFs were back in the 90s, and it's been a long time. I think we've seen one set of RIFs at Local 17. There was a group of, before we went to Microsoft Teams, before that there was Skype, we had the VANCE, the telecommunication system. And there were about 10 employees in West Virginia that dealt with the phone system, teleconferencing. And they were eliminating that. So they said, you're riffed, see you later, adios. We filed a demand to bargain. Actually, we were able to get them retrained, and now they're in positions, higher graded positions. So that was a great success story. And some of our stewards, I think it was Marlo or Derek and Colleen Kedem did that. For this, though, now the reasons you outlined for having a RIF, there's not enough money, the jobs, the positions disappear, like the telecommunication system. Now, is there a way to challenge the reasons why they're doing these RIFs? Is it to go in and say, we want to cut $83,000 or 83,000 positions because we're into efficiency, but there's really no rationale behind that. Is that something that can be used to challenge a RIF successfully?
Well, you could try. People have tried that with the Merit Systems Protection Board, and my recollection is they don't do so well. The MSPB will not look behind management considerations, assuming that it's passably rational. Again, sometimes you get these one-person RIFs, they become a little suspicious. That's not to say they can't be sustained, but that's not going to happen here. Now, an arbitrator, who knows what an arbitrator will do? Arbitrator, they do whatever they want. They want to say, you come up with all the budget justifications for this and tell us, what the executive office of the president told you and what did the OMB do and turn this into a big accounting exercise. They can do it. So it is possible. The MSPB, in my estimation, won't do it. And arbitrators, the agency will argue to them, well, you need to follow MSPB law. Well, I don't know. The Supreme Court said you have to do it in adverse actions in Cornelius versus Nutt many years ago. RIFs, the Supreme Court hasn't cut that fine. And, if an arbitrator does that, where do you go? You take it to, the agency takes it to the Federal Labor Relations Authority. Good luck with that. The FLRA is not too likely to set aside an arbitrator's reasoned judgment. So I would say you would have a better chance with that type of argument with an arbitrator than you would with the MSPB. Back in the days of all those furloughs, the tens of thousands of furloughs that the unions urged people to appeal to MSPB, people used those arguments as well. Well, management really didn't run out of money. They just shifted it here or there. And by the way, it's sitting in a coffee fund over here. But, the MSPB just didn't get enthralled about that, similar to their decisions and RIFs. But arbitrators, some of these arbitrators, man, they do some very strange things. So you might get lucky.
Listening to you and what I've read about these RIFs, it seems to me this would make more sense for the administration instead of doing this with the sledgehammer. And there's going to be just an enormous amount of litigation. and a lot of resources thrown into this. I think it would be a better approach maybe to just do the voluntary early retirement authority. I mean, statistics show that there's a lot of people in the federal government who are retirement eligible or really close to retirement eligible. And let's face it, the federal workforce has been demoralized. I've talked to people at VA central office, and they said they don't even want to go to the cafeteria. They don't want to see people, and people are just ready to leave. I mean, that's kind of like they're taken out of their toolkit is just make federal employees miserable, and demoralize us and have them ready to leave. And I think if they offered something like that, I think they'd get a lot of people taking these early retirements, and I think it would save an incredible amount of money and resources. Do you have an opinion on that?
Sure. Well, I think it will happen. I mean, that was the fork in the road program, right?
Yeah, that was
go
different.
away. We're going to give you 7 or 8 months pay, take a vacation someplace nice. And by the way, the agency, if they have the authority from OPM, will offer voluntary early retirement, and people will accept it. So yeah, I think the agencies, if they're granted the authority from OPM, which I expect they will, after all this stuff, I look at this stuff and I say, wow, you fire 10,000 probationers, courts tell you to bring them back with back pay and so forth. This isn't coming out of the administration's pocket. This is taxpayer dollars that are just being blown away to screw around with this system. And if you just do it right, you would accomplish your result, which is downsizing the federal workforce. And you save the taxpayers a lot of money. And I think one way to do that is, as you say, offer them an incentive, which is the early retirement. Go find another job, get lifelong benefits from the federal government. Good luck and goodbye. Makes sense to me, but nobody put me in position to make decisions,
That's too bad.
I give you a decision that might be wrong.
I think they should listen to people like you, and I think it would go a lot smoother. And you're right, it is taxpayer money, and everybody should be concerned. All taxpayers should be concerned with what's going on here. But anyways, we have to wrap this up. It's been an hour. I don't want anybody to get in trouble. But thank you so much, Peter Broida. This was an incredible presentation. And I think the more people understand about RIFs, the more it's not so fearful, because it is a complex process when you first dive into it. And you made it incredibly clear and easy to understand. And we just want to thank you so much for being with us today.
Well, Doug, thank you for the invitation. I owe my career for the past many years to more than 40 years doing this type of work to AFG and its then General Counsel, Lou Poerzi, now deceased. And it's an honor anytime that I'm asked to speak to an AFG group. So thank you.
Thank you very much, sir. Have a good day. And, I got some Zyrtec before this. I had the allergies. And I want one of those medicines, I want to recommend that because it went away like in an hour. So
I'll keep that in mind. I need something. All right. See you later. Thanks, Doug.
Take care. Bye-bye, Peter. All right. Thanks, everybody. Just want to give you an update. This is our second podcast on RIFs. We may have a part 3 and part 4 because I think getting the information out there is very important to people. We do have a podcast. We'll put it out there. We had a social worker talked about maintaining mental health through this. He's a local social worker, licensed clinical social worker with a practice in Silver Spring, and he does see a lot of federal employees. So that may be good to see after this video if you're all worked up about RIFs. But one thing, the main takeaway that I hope you got from this is going to take time. There are notice requirements, 60 days, OPM regulation. Our contract has 90 days, which is even more. It's very complex, and there's a lot of ways for the department to make mistakes. And AFG Local 17 is going to be there. The National VA Council is going to be there for you. And if you're in the bargaining unit and you haven't joined AFGE Local 17, please do so. If you go to www.joinafge.org. It's very simple. You can join in about 10 minutes using your credit card or your bank account. So anyways, thank you very much, everybody. We appreciate it, and we'll be back again soon. Take care.